करता हूं। धन्यवाद। भारत माता की जय।
श्री भर्तृहरि महताब जी।
Thank you, Mr. Chairman. Last time when my friend Mr. Shetty started the deliberation on this bill, I was listening to his point of view. And today, of course, again he has expanded on that viewpoint. The issue that is before us through this bill is derecognizing national parties on certain conditions. That is what the crux of the matter of this bill is. And what is the end result? That we should have less number of national parties in our country, which do not get adequate public support in the last election in a percentage wise, and ultimate result would be there would be only one or two national parties in the country. Does this adhere to the constitutional provision of our country? Does the constitution makers who deliberated for more than two years, 7 months, this issue also was before them, that we should confine our national parties to 2 or 3 or maximum 4. That was the point of debate. But ultimately, cutting across party line, cutting across different school of thoughts, it was decided that we should have a multi-party system. And in a multi-party system, if you put conditions, as has been proposed by my friend Gopal Shetty ji, you are violating the thought process or the decision of our constitution makers. They did not comprehend that such a thing will be deliberated in a house of people like Lok Sabha. Yes, people can go to the Supreme Court. As I have been informed that Mr. Ashwini Vaishnav, who is now the Railway Minister and also Minister for Communication and IT, he had been to the Supreme Court. I'm yet to find out whether that time he was a member of Rajya Sabha or he was just a citizen of this country, just a citizen of this country. But anyone can go and knock on the door of the Supreme Court of India on any issue, because that provision is there in the law, and Minister of Law is present here. He can also vouchsafe it, that this provision of raising any matter before the Supreme Court was not there earlier, which came much later. That, of course, Justice Bhagavati is always remembered that by sending a postcard to the Supreme Court, that thing also can be taken cognizance of and can be deliberated in a bench. But the writ condition that came into existence much later, I should frankly mention it here that I am not a lawyer. Neither legal activities is my profession. But the activity that I indulge in, my profession is journalism. And in that respect, I can only say that these are certain matters which we also always deliberate in our media circles. Because what is happening in Supreme Court, what is happening in the Parliament is a point which other people also should come to know. And that's how my friend Mr. Gopal Shetty has raised that issue, that his colleague or our colleague, Mr. Ashwini Vaishnav, if he is the same person, has raised it in the Supreme Court of India. And what did the Supreme Court say? You mentioned Ashwini Vaishnav. Yeah, I said Ashwini. Then I stand corrected as Mr. Ashwini Upadhyay is, then that needs to be corrected. No, he said Ashwini Vaishnav.
Okay. Yeah.
He repeated that name.
I'll let it be corrected. Okay.
क्योंकि अश्विनी वैष्णव तो एक ही है. Yes. But I would say, yes, if an individual has raised it or a lawyer has raised it in the Supreme Court of India, what did the Supreme Court say? Did they give any final judgment on that issue? Number of issues are going to the Supreme Court, even to the High Court. Not taking a decision, if we say that, is also a decision. And here, the Supreme Court has not taken a decision. Supreme Court, perhaps, my interpretation is, perhaps, did not want to give a decision on this. Rather, they didn't want to enter into the sphere of Election Commission. They have referred that matter to the Election Commission to take a decision. I'm not aware what Election Commission will decide or has decided. The mover of this bill did not say this, that when was it referred to the Election Commission? And how long will Election Commission take to take a decision on that subject? But the matter before us is limiting the number of national parties. Two aspects needs to be looked into. One is, can we limit the national parties as per the provision that is prevalent today? And for that, he has suggested certain amendments in the Representation of People's Act. The other aspect is, do we benefit if national parties are limited to a certain number or on certain provisions? This reminds me that when today Bharatiya Janata Party is present, is having government in number of states, how many states are left? Of course, now Himachal Pradesh has gone out of the fold of Bharatiya Janata Party. How long will it continue? That's another matter. But starting from Kerala, Tamil Nadu, Telangana, Andhra Pradesh, Odisha, Chhattisgarh, Jharkhand, West Bengal, these are non-BJP government states. But the rest has, and Bihar, but the rest have BJP in government, or BJP also is a partner in the government. Imagine the situation of 1948 or 50 or 52. Interim government was there, then the first Lok Sabha was held in 52 and the government came. Throughout the country, it was Congress government. Throughout the country. In 57, there was little change, but from 52 or from 47 till 57, it was only Congress. And they decided we should have multi-party system. They decided, taking other school of thought, other people's opinion into consideration, the constitution makers made that this is the provision of a national party and of a provincial party or a state party. They did not restrict. And what was the composition of Lok Sabha during that period? Shama Prasad Mukherjee was the lone member of Jan Sangh. Hiren Mukherjee and there were 3 others from Communist Party. Weren't they national parties? And today, my friend Gopal Shetty says, derecognize them don't give them national party status. Where have we landed now? After 75 years, do we believe that giving recognition to national party is choking our democratic system? Is it weakening our representative character of our democracy? This question also needs to be debated. It's not that simple when my friend Mr. Shetty has moved this bill, that these are the conditions through which we should de-recognize them. And what are those conditions? And before that, I should say, what is a national party? And what benefit a national party, if a party is recognized as a national party, how does it benefit that party? A national party has the right to a reserved symbol for its candidate contesting across the country. The party is also entitled to land or a building for its national headquarters. Candidates from national parties need only one proposer to file nominations as opposed to two or more. They also get dedicated broadcast slots on Doordarshan and All India Radio during the general election. These are the four major or broad benefit a national party has after being recognized as a national party. But I would like to remind this House before the anti-defection law came into existence, before 10th schedule was added into the Constitution, there was no mention of party in the Constitution. Party was not recognized by the Constitution makers. It was never mentioned in the Constitution at all. What was mentioned? Association. Association is the word. When group of people, they congregate and they decide to form an association and want to be registered before the Election Commission as a national party or as a state party. Recognition is provided on certain conditions. And here I would say a political party, I would come to this little better later. I would say in the registration of political parties, any association or body of individuals, individual citizens of India, no mention of party, calling itself a political party and intending to avail itself of the provisions of this part shall make an application to the Election Commission for its registration as a political party for the purpose of this Act. And this is Representation of People Act 1951. This is the Act. And therefore, I would say party is recognized after 10th schedule came into existence. And there was an amendment subsequently, perhaps in allocation of election symbol, where in 2003 and again in 2005, rules were framed, and there classification of political party came into existence, where for the purpose of this order, I quote, and for such other purposes as the Commission may specify, as and when necessary, therefore arises, political parties are either recognized political parties or unrecognized political parties. A recognized political party shall either be a national party or a state party. And conditions for recognition, I am referring to 6A, and I believe the Minister government will go through this. I find it little incongruous because in the footnote it is mentioned 14th May 2005. This is in page 201 in Election Symbol Reservation and Allotment Order 1968, Statutory Rules and Order. I think there is a mistake here. It should be conditions for recognition as a national party, but here it is mentioned as a state party. 6A. A political party shall be eligible for recognition as a state party in a state if and only if any of the following conditions is fulfilled. What are they? 1. At the last general election to the Legislative Assembly of the state, the candidates set up by the party have secured not less than 6% of the total valid votes of the state. And in addition, the party has returned at least 2 members to the Legislative Assembly of the state at such general election. Or, at the last general election to the House of the People from that state, the candidates set up by the party have secured not less than 6% of the total valid votes polled in the state. And in addition, the party has returned at least 1 member to the House of People from that state as such general election. There are 2 other points also. At the general, and this is that it will be recognized as a state party in that particular state. And what is our amendment that we are deliberating here? The amendment is not less than 10%. The number of members belonging to the political party in the House of People is not less than 10% of the total number of seats in the House of the People. And second is, have been elected from not less than 1/4 of the total number of states. These are the 2 major amendments which Mr. Gopal Shetty, Honorable Member, has moved. And not less than 10% of the total number of seats in the House, and have elected from not less than 1/4 of the total number of states. It gets a national character. That is the idea behind this. And then he comes to B. At the last general election to the House of the People, the candidates set up by the political party secure not less than 16% of total valid votes. At the last general election to the Legislative Assembly, the candidates set up by the political party secure not less than 16%. So as I had said earlier, the basic idea, which I understand, the limited knowledge I have of English, I can say this, that perhaps the mover of this bill does not want a multi-party system in this country. He has mentioned about national party, but the hidden agenda, which I believe is not to have multi-party system in the country. Is it advisable in a vibrating democracy? Our Honorable Prime Minister repeatedly is saying that we have a vibrant democracy. And here one of his party members is saying, limit it, limit the party. I am of the opinion, sir, when 2 members can form an association, why should you restrict? That power is with the people. They may elect, they may just reject. Isn't this the House which had elected only 2 members from Bharatiya Janata Party? Was it de-recognized then? It was not. And subsequently, what is the position of Bharatiya Janata Party in our country? It has more than 300 members in this house. So it is left to the people to decide why we should restrict the recognition of a political party through an act. This was my first point of contention. I would also say, sir, as per Election Commission, a political party shall be eligible to be recognized as a national party if it secures 6% of valid votes polled in any 4 or more states at a general election to the House of People, to the State Legislative Assembly, wins at least 4 seats in the House of People from any state or states. It wins at least 2% seats in the House of People, and these members are elected from at least 3 different states. There was a time we have all witnessed Communist Party of India got divided in 64. One was CPIM and another was CPI. But it came to such a situation that Communist Party of India, you have seen yourself and I have seen also, Mr. Indrajit Gupta was leading the party here. There were Hiran Mukherjee who was sitting in the right side of this house. They were stalwarts, adhering to democratic norms and fervor, ventilating the people's point of view in this house. But at another point of time, their party diminished. And we still have some members from that party in this house. I would say it was a national party, and for different reasons, when they lost their position in number of states, it was also the national party recognition also it lost. So also it happened with Swatantra Party. It also lost. So I would say there are provisions in our constitution that there is no need to have this type of amendments. And I would say my limited point here, short point is, these amendments, I would conclude by saying, perhaps the mover of this bill wanted an academic discussion. But the moot question is that only after the 10th schedule, as I stated, party came into recognition in our constitution. Party whip was given much importance. Individual liberty got curtailed in the house. Whatever is to be said in the house has to be dictated by the leader of the house. That's how we have progressed since 1985, during Rajiv Gandhi's time, when Congress had 2/3 majority in this house. And subsequently, another amendment also came that I just now mentioned. But the party recognized by Election Commission is nothing but an association of persons. A single person cannot form a party, but a single person can represent the people in this house. I believe that my request would be to the mover of this bill, my good friend Gopal Shetty ji, that ours is a very big, large country, has different type of people who want to maintain their identity. Should we de-recognize them, saying that you are not national party? And should so for the glaring example is All India Anna DMK. It's the All India Anna DMK. All India Trinamool Congress. And in how many states are they present? But they are all India parties. Might not be the national parties, I'm not aware about it. I think Mr. Gopal Shetty may do certain investigation on that aspect. But my humble request is that do not restrict. I'm always for multi-party system in our country. And that is the reason why we have thrived for last 75 years. Last point which I would like to mention here. It was during the Ashoka's time, some 2,300, 400 years ago. The landmass that today India is, or little more than that, was under one government, one king, that was Ashoka. Subsequently, after that, for more than 2,400 years, if we leave out 1947, the India that is carved out today, at no point of time, during the Mughals, about which we read so many things in the history book, it was never under one government. It was only after independence, because of our struggle of our freedom fighters and the constitution makers and stalwarts of our country, this country got united under one government. We have provincial government, but union government is one. For the first time after 2,000 years. And it is still vibrant because we have multi-party system. We are not restricting people from forming association. And if this is so, my good friend should also understand that this bill, we may have a deliberation for academic interest, but this is not the time or will never be the time for the benefit of our country's democratic temper. Thank you, sir.
भर्तृहरि मेहताब जी का
बाद में भी आप बोल सकते हैं at last when the
चलेगा?
debate is complete.
Okay, as you wish.
Please, you know, whatever honorable speakers say
Yeah.
here, you just note it and then reply it in finally.
Yeah.
अभी कुछ कहना चाहेंगे?
हाँ, अभी इनका कह देता हूँ ना।
चलिए कह दीजिए।
मैं भर्तृहरि मेहताब जी का बहुत हम सभी लोग यहाँ पर सम्मान करते हैं और बहुत ही स्टडी करते हैं, बैठते हैं, विषय को समझते हैं और हम सब लोगों को मार्गदर्शन करते हैं। मेरा मुद्दा, और उन्होंने मुझे और ऐड कर दिया, उन्होंने जब संविधान लिखा गया तो उस समय के लोगों ने भी इस बात का विचार किया था कि इतने बड़े देश में राष्ट्रीय पार्टी कितनी होनी चाहिए, 1 होनी चाहिए, 2 होनी चाहिए, 3 होनी चाहिए, 4 होनी चाहिए, ज़्यादा नहीं होना चाहिए। फिर बाद में डिस्कशन और डेलिब्रेशन के बाद में तय हुआ कि नहीं, ऐसा ऐसा होना चाहिए और उसके हिसाब से देश चल रहा है। लेकिन जो वर्तमान में जो अनुभव हम पा रहे हैं, उस अनुभव के आधार पर मैंने ये कहा कि जब कोरम होने के लिए इतनी की संख्या है, एक पॉलिटिकल पार्टी को मान्यता प्राप्त होने के लिए कितने % वोट मिलने चाहिए, कितने राज्य में उसका कितने MLA होने चाहिए, MPs कितने होने चाहिए, इसका एक मापदंड बना हुआ है। उसी तरह से लोकसभा में भी उसके मेंबर कितने हो तो उसको राष्ट्रीय पार्टी का मान्यता मिलना चाहिए। भारतीय जनता पार्टी एक ऐसे खुले विचार की पार्टी है, कोई किसी को बड़ा होने से हम तो कभी रोकते नहीं, तो ऑन द कॉन्ट्रेरी वी हैव सपोर्टेड द पॉलिटिकल पार्टीज टू बिकम बिग। एक नहीं तो 10 एग्जाम्पल हम दे सकते हैं। इसके लिए 130 करोड़ 135 करोड़ वाला ये भारत देश में आने वाले दिनों में कोई भी कुछ भी कहकर चुनाव जीतकर राष्ट्रीय स्तर तक पहुंचते हैं तो उसके बारे में मैंने ये कहा कि हम लोगों को चर्चा करना पड़ेगा। मैंने ये भी कहा कि सभी पॉलिटिकल पार्टी के लोगों ने बैठकर इसके ऊपर विचार विमर्श करना चाहिए। मेरी जो सोच थी वो मैंने कही और मैंने कहा कि डिस्कशन और डेलिब्रेशन के माध्यम से ही जागृति आएगी, वर्तमान पत्र के लोग करेंगे। ये सारी बातें मैंने बताई थी, इसलिए मुझे धन्यवाद उनको इस बात का ही देना था कि उन्होंने मेरे नॉलेज में और थोड़ा एडिशन कर दिया कि संविधान जब लिखा गया था तब भी लोगों ने इसके ऊपर चिंता की थी और इतने समय के बाद में भी हम लोग इसको अगर टच नहीं करेंगे तो ये अन्याय हो जाएगा। थैंक यू सर।
आपका राइट टू रिप्लाई है, तो बाद में जब चर्चा हो चुकी होगी, बाद में आप अपनी टिप्पणियां